Would you like to learn how two different medical experts, one for the plaintiff, one for the defense, looking at the same exact set of medical records, can reach two opposing opinions and conclusions about what happened to you? And importantly, how is a jury going to come to a decision about whether or not one expert is more likely right than wrong? Would you like to know the answer? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. In a medical malpractice case in New York, we are required to obtain all of your medical records and have them all reviewed by a medical expert before we are permitted to start a lawsuit on your behalf. The medical expert has to confirm that the doctor was careless, that he violated the basic standards of medical care, and that carelessness was a cause, it doesn't have to be the cause, was a cause of your injury, and that your injuries are significant and or permanent. Now, at some point later, once we have confirmed your case, once we have started your lawsuit, the defense, the attorney who represents the doctor and the hospital staff, will have an opportunity on their own to obtain all of your medical records and have their own expert review those records. How is it that the defense expert, in almost every single instance, is going to come to a totally opposite and different conclusion than our expert? Regardless of how they reach their opposite conclusions, the fact remains that in almost every instance, they have opposite opinions. They have different opinions. We claim the doctor was careless. They say, no, he wasn't. We say that whatever the doctor did caused you harm. They say, even if the doctor did something wrong, whatever he did not cause you harm and injury. And we say that not only did the doctor's carelessness cause you injury, but that your injuries are significant and permanent. And they turn around and say, no, no, no. Even if the doctor was careless and caused you harm, your injuries really are not as bad as you claim them to be. So they will dispute virtually every single claim that you make. How is that possible? I'll tell you how it's possible. Because these experts, at least the theory is, have different agendas. The theory is that based upon who is paying them, they will generate an opinion favorable for the attorney who is paying them. I will tell you something that most people don't tell you. The fact is that when we hire a medical expert, I want them to tell me the truth. I want them to tell me their honest opinion. I don't care whether it hurts or helps. I need to know. Why? Because if I know at the very beginning that my client does not have a valid case, I am prohibited from going ahead and ethically starting a lawsuit on my client's behalf. In addition, if I know at the very beginning that my client does not have a valid case, why would I go ahead and invest my time, my energy, my resources, money to go ahead and prosecute my client's case, since my firm will be laying out every penny to prosecute this particular case? And if we are ultimately unsuccessful, I get nothing. I get absolutely zero. So why would I ever want a medical expert opinion that is not accurate? I don't want that. I need to know upfront an honest opinion. And if my medical expert, who I believe is qualified and has the credentials necessary to review these records, tells me, yes, the doctor violated from the standard of care, and yes, that violation from the standard of care caused this patient harm and injury, and yes, these injuries are lifelong and disabling and permanent, now we have a valid basis to proceed forward. The defense somehow reaches the opposite conclusions, and now the question becomes, if they are looking at the same exact sets of medical records, no different. We all know exactly what the facts are. We have the same set of facts. There's only one set of facts. Yes, there are disputes between what my client has to say and what the doctor has to say about factually what complaints were made and what the doctor recalls happening. That's understandable. But from a standpoint of what should be done in various instances where the patient comes in complaining of a certain problem, and now what is the obligation of the physician at that point? What should be done? What should not be done? Now that should be clear cut. But the reality is that in these medical malpractice cases, they are not. We have opposing factual issues. We have opposing medical experts who are now disputing each aspect of the standard of care, and what ultimately happened to you, the patient. Okay, so the question I raised in the title of this video is, how is a jury, when your case goes to trial, how is a jury able to decide who is right and who is wrong? And I'll tell you how. And I'll tell you, it all comes down to this: credibility. Who is more believable? That's all it comes down to. The jury must now decide at the time of trial, after listening to all the testimony, after listening to all the evidence, who is more believable? Are you, the injured patient, more believable than the doctor? Is what the doctor's saying, does that make more sense? Is he more believable? Is our expert, the plaintiff's expert, more believable than the defense expert? Now, if we bring in 2 experts and the defense brings in 5 experts, the fact that they brought in more experts, does that mean that they are more believable? I will tell you the answer is no. However, some people might have that opinion. So how does a jury determine who is right and who is wrong? It all comes down to credibility. Who is more believable? And at the end of the trial, the judge will give the jury legal instructions that they are the ones to evaluate and to determine who is more credible, who is more believable. And now the jury will have to decide amongst themselves, 6 members of the community, to decide who they believe. And ultimately, they have to come to a consensus. 5 out of 6 jurors have to reach the same decision on whether or not the plaintiff, you, the injured patient, are more likely right than wrong than what you are claiming is true. So why do I share this quick information with you? I share it with you because I'm going through a case now where I'm dealing with a motion for summary judgment, which means we've now completed the discovery phase of my client's case, and now the defense is doing everything possible to try and get my client's case thrown out before we ever get to trial. And in order to do that, they have to submit a medical expert affirmation. In other words, they have to have a medical expert review the records. And now, as if they were testifying in court, this is all done on paper. They have to set forth the expert's opinions. And after that, I then have an opportunity to respond and to oppose this request to throw the case out. And I have to bring in my medical experts to show to the court on paper that my experts have reviewed these records. My experts have reached totally different opinions and conclusions. And now it is not up to the judge to make the decision about who is more right than wrong. Instead, that is a question of fact to be decided by the jury at the time of trial. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York, and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.